Hello everybody. Thanks for joining. It's the 28th edition of the Swiss Patent Litigation Fireside Chat. Normally it's the last Wednesday of a month. I had to defer it for 2 days this time. I was listening to a hearing at the Federal Patent Court this Wednesday, so this is the reason why we have it this time on a Friday, and it's, well, the first Friday of the next month, not the last Wednesday of the current month. But the good thing about that is that I can tell a few words about the hearing that I attended earlier this week on Wednesday. I have brought 3 decisions of the Federal Patent Court with me that I wanted to briefly present today, and as I said, the quick report about the hearing of last Wednesday. So starting with the first judgment that I wanted to briefly touch upon, that's quite a saga. Meanwhile, it all started with the judgment of the Federal Patent Court of 17th of August last year. The buzzword of that case is Randanschlusselement. It's a construction industry. And in that judgment, that was a partial judgment on infringement, and infringement was confirmed. And at the same token, in the same judgment, it was also a prior user right affirmed for the defendant. And that case went to the Supreme Court. And the Supreme Court essentially said, well, it doesn't seem reasonable to give a prior user right, obviously, because that patented something had been previously in use, and at the same time order an injunction and hold there is an infringement, because apparently the patent might not be valid in the end. So the Supreme Court held that this does not really fit together. And, well, that case was then remitted to the Federal Patent Court. It got a new case number. Now it's 02023-004. And the Patent Court in that judgment now, taking into consideration all the orders by the Supreme Court, walked again through validity on all requests and for all attacks more or less precisely presented by defendant, and held that the patent was invalid, so the complaint was dismissed, contrary to the first judgment. And yeah, I can't tell much about that case, or I don't want to do that right now, because we are involved in that case on behalf of the plaintiff. So it's really only about a report of the status quo. Again, an appeal is pending, so this case again went up to the Supreme Court, and I promise once that case is finally decided, I will set out all the nitty-gritty details of that case. Currently, that is the structure of events. It is up to the Supreme Court for a second time now, and yeah, it might still take a few months until we hear back from the Supreme Court with a final judgment on that case. Moving on to the next case, on which I can tell a little bit more. We are not involved in that case. This is litigation between 𝗏 and Revolt Cycling. What you can see here is a bike of the defendant, of the brand Opium, and that case has been, it has been dealt with by quite some courts. Meanwhile, it's not only the Federal Patent Court that is involved in these disputes between the two parties. The 𝗵𝗄𝐶 also had already ordered a closure of a booth at a trade fair last year. So there is quite a few things going on in that case. This summary proceedings here, that's combined proceedings as 2023-004 and 5. One of these summary proceedings is, well, pretty much straightforward, the request for interim injunctive relief, classic PI. And the other case is about a seizure of bikes at the customs, at the Swiss customs. And these combined proceedings, there will be oral proceedings in December. I will get back to that in a minute. But this judgment or this order that has been published here, what about the competence of the Federal Patent Court? And here's the head note of this procedural order that relates to Article 26 of the Federal Patent Court Act and Article 90 of the Civil Procedure Code. In the official English translation, the head note reads, the Federal Patent Court does not have subject matter jurisdiction for claims based on other intellectual property rights that are combined with patent claims. And the German wording is 𝗕𝗂𝘃𝗽. Now, what has that case been about? You will get it from this illustration here. I need to take that off here. On the left side, you can see a design registered on behalf for the plaintiff. That's a design registration. That's pretty much the whole bicycle and the frame of the bicycle, which is protected by that design right. And the other proceedings at the Federal Patent Court that are pending between the parties are about a patent right, which is here on the right. That's a European patent that is at stake. That is really all about the well, quite sophisticated details of the dropout of the rear fork. And the Federal Patent Court, in a nutshell, held, well, even though it's about a bike in 2 cases, it's not the same request for injunctive relief that is at stake, because the precise geometry and the details of the dropout are simply not what the design registration on the left is all about. So this is what the head note of this order says, when it's really only about a Klagehäufung in German, then the Federal Patent Court does not have subject matter jurisdiction on that, even though it's about more or less the same bike. So the interesting thing here is it's of course not finished with this procedural order, and I've here on the screen a LinkedIn post that I made on the forthcoming hearing between the parties. There will be a hearing on the 19th of December in the combined proceedings 004 and 005 of this year, and yeah, it's about a summary judgment on the PI, and I've included in that LinkedIn post all the prior art that is cited by the defendant in order to show that the patent claim is invalid, and also the seizure of the opium bikes at the customs and at the border will also be at stake at this hearing. So if you're interested in that case, that will definitely be a hearing you might want to attend. I will definitely do so. So that is about this case. Moving on to the next case. That is an interesting case. It's about a startup that stems from a Swiss university, the 𝗺𝗵𝗄𝗄, and the startup startup's name is WindShape, and obviously there was a patent licensed out to that startup, and the university had an option to get 10% of the shares of the startup once that startup would be converted to a limited company, an Aktiengesellschaft. And what the contract required was that the startup puts the university on notice of that envisaged change to a limited company. And then a certain deadline, I think 30 days, started for the university to exercise its option on these shares of 10% for free. And yeah, the startup did so and put the university on notice, but apparently the university did not respond in due time, and after the time had lapsed, the startup refused to give these 10% of the shares for free. And the judgment is in French, but when you go through the judgment, there are some, well, snarky comments, I would say. Here is one of those snarky comments. Apparently, the startup did not send this notice to their usual context, but just addressed it to the university. But that was apparently fine according to the contract that was in place. And the judgment says, in my translation, there is no legal obligation to be kind. You don't have to make it easy for the other party, you just have to comply with the contract. So there is no legal obligation to be kind. So the university's request that the license under the patent be revoked, and that it should get the 10% of the shares, or that there is a special ground, an important ground for the license to be revoked. All these requests were dismissed simply because, well, the startup did nothing wrong according to the contract. It just hasn't been kind and did not more than it was obliged to do. But what it did was accordingly was obviously fine according to the contract. So that will be interesting to see how that plays out in main proceedings, which are pending. I will, of course, follow that case. But for the time being, the university's attempt to at least get rid of this licensee failed. So the startup still has a license under the patent and owns 100% of the shares because the university did not exercise its option in due course. So that is what I can say to that case for the time being. Now moving on to the next case, which is not yet a judgment. It's only a report of the hearing of last Wednesday. Again, that's a case where our office is involved. That's litigation between 𝗵𝗲 Pharma and BMS, Bristol Myers Squibb. And that's litigation about 𝗕𝗂𝘃𝗃. That's an anticoagulant pharmaceutical. And this pharmaceutical is litigated in quite a number of countries right now. The interesting thing about that case is that the two most recent decisions of the Enlarged Board of Appeal of the EPO are playing an important role in that case here. The first issue is about the priority claim, because the priority application, which was a US provisional application, was not in the name of the later applicant of the PCT application and then the granted European patent. So the priority application was filed by a company within the same group of companies of the later applicant, but it still was not the same applicant. And as you all know, the Enlarged Board of Appeal recently held that there is a rebuttable presumption that everything will be all right with respect to the priority claim. I have heard in the hearing on Wednesday that BMS essentially argued that the Enlarged Board essentially said there are no inappropriate priority claims anymore, because the later applicant must have benefited from the help of the priority applicant, because otherwise he could not get hold of the file number, the filing date, and the certified copy of the priority application. So BMS held there are practically no unlawful or illegitimate priority claims anymore. Of course, the plaintiff sees that differently. It's a rebuttable presumption, and 𝗕𝗂𝗧 is currently convinced that the presumption is or has been rebutted. Interestingly, it has been BMS's initial position that they had beneficial ownership of the priority application anyway, and there was a court opinion being ordered from a US expert, a US law professor, and that opinion has been rendered, and that opinion very clearly holds no, there was no beneficial ownership. BMS now argues, well, this is moot now anyway in view of the enlarged boards of appeal decision that has been rendered recently. Yeah, we shall see. So that's the first interesting aspect on that case. And the other interesting aspect is about plausibility. The BMS patent stems from a PCT application with a few hundred pages, and of course, 𝗕𝗂𝘃𝗃 is mentioned somewhere in that application, and the parties are obviously in disagreement whether the claimed effect in the second medical use claim or the effect that is relevant for the assessment of inventive step for the product claim was plausible, even though that word should not be mentioned anymore. But that's a point of disagreement on that issue. And if you followed the blogs recently, it's been interesting to see the developments after the decision of the enlarged board of appeal on plausibility. There was a judgment in the UK, as I said. That case is litigated heavily in many jurisdictions. The only, to the best of my knowledge, the only final decision has been handed down in the UK by Judge Arnold, by the Courts of Appeal. And Judge Arnold, in full knowledge of the decision of the enlarged Board of Appeal, said, I apply it my way, and I apply it. And Judge Arnold came to the conclusion that the patent on 𝗕𝗂𝘃𝗃𝗃 is invalid. Other courts, even though not in a binding, in a final instance judgment, I think in the Netherlands it was a PI, they came to a different conclusion. And interestingly, the enlarged Board of Appeal, of course, had rendered came to a conclusion and remitted the case back to the referring board. And the referring board, 3 or 4 days ago, took the case at hand again, and also had a look at the judgment in the UK by Judge Arnold, who applied the reasonings of the enlarged board, and the referring board of the EPO somehow feels that Judge Arnold got it wrong, that Judge Arnold applied the reasoning of the enlarged board not properly. So that will definitely be interesting to follow, and that's the second enlarged Board of Appeal decision on plausibility here that will come into play in the judgment in that case here. Yeah, what we have learned from the hearing is that apparently the panel of judges did not deliberate immediately after the hearing on that case. I heard that they will only deliberate on that case in January, and in the end it was said that the judgment should not be expected before March. So yeah, there's a lot to decide there, but that will definitely be one of the milestone judgments. I would say it was a panel of 5 judges. It was an enlarged panel. And it will be interesting to see how these two enlarged Board of Appeal decisions will be implemented into practice by the Federal Patent Court. So yeah, we shall see next year how that case finally unfolds. So that was what I brought with me today, the 3 judgments and this report from the hearing. As always, if you have any comments or questions on what I have reported about today, please feel free to leave a comment on LinkedIn directly below this LinkedIn event page. And of course, I'm happy, or I would be happy if you follow my blog, Patent Litigation CH, and sometimes I'm a little slower with the blog post on the blog, but leaving a post on LinkedIn sometimes it's quicker. So if you want to follow me on LinkedIn, I would be happy if you did that too. And so this was it for this month. Quite likely I will not make a fireside chat at the end of December because I hope for you, all of you will be on Christmas holiday anyway. So I hope to see you back again for the next fireside chat in January. So thanks for joining and hope to see you again next year. Best wishes for December and for the end of the year seasons. And yeah, hope to see you again next year. Bye-bye and have a good lunch if you didn't have it already. Thanks for joining and bye-bye.